Thank you, Madam Chair. Reverend Risher, I too have had the opportunity to meet with some of the survivors of that tragic day, and so thank you very much for your heartfelt reminder of the work that remains for us to do.
Thank you.
Professor Kinkoff, you've written a lot about the unitary executive, and that's something that Mr. Barr subscribes to. So I found it really interesting what you mentioned today, because there were a lot of questions from so many of us seeking reassurances from Mr. Barr that he would not interfere with the Mueller investigation in any way, shape, or form. And today, though, you said those assurances are irrelevant because under the unitary executive theory, that if Mr. Barr were asked, can the president fire Mr. Mueller, Mr. Barr would say yes. So there goes the entire investigation. I found that to be a really interesting statement on your part. So that means that, so let's say that if the president does fire Mueller, and one would say that under a normal circumstance, that kind of firing could be part and parcel of an obstruction of justice kind of an investigation. But if the entire underlying investigation goes away because the investigator is fired, then where are we? So that's very interesting as we sought to see the kind of reassurances that would enable us to feel that the Mueller investigation is in fact going to be able to proceed. So you talked a little bit about what the impact of the unitary executive, and I do that theory, and I do understand that there's a range. It's not, you know, there's a continuum there. So I just want to ask, under the unitary executive theory, can a president commit obstruction of justice with impunity?
So I'll answer based on the memo that
Yes.
Mr. Barr wrote last summer, because as you say,
Yes.
there's a range, and so the answer would be different depending where you are on the range. The Barr memo allows that there may be circumstances where a president can be understood to have committed obstruction of justice. Now, that's different from saying the president can be charged with obstruction of justice, and in fact, Mr. Barr yesterday during his testimony said he sees no reason to deviate from the department's policy that a sitting president can't be indicted. But even within that construct that a president can commit obstruction of justice, it's really difficult to see on his theory how that would end up happening. Because he says when the president exercises a legitimate executive power, that cannot provide the basis for an obstruction of justice charge. And therefore, if he exercises his authority to fire someone, James Comey is the discussion in the memo, then that cannot be the basis of an obstruction of justice charge. If President Trump then used his authority to fire Mueller, that, by extension, wouldn't be something that could serve as the basis of an obstruction of justice charge on the theory set forth in the memo. And I think he should be at least asked in follow-up questions whether or not he would apply the logic of the memo to that situation. And he should be asked, if that were to transpire, would he resign? Because I think yesterday he indicated that that would be an abuse of power. And that's something an attorney general should resign if the attorney general sees.
I think you have given us a further line of questions to submit to Mr. Barr. Regarding the Voting Rights Act, so this is for Mr. Johnson and Mr. Muriel. We know that after the Shelby County decision, there were many states that passed all kinds of legislation that would be considered by a lot of us as voter suppression. And yesterday, Mr. Barr testified that he would vigorously enforce the Voting Rights Act, the Section 2 of the Voting Rights Act, to the two of you. Since there has not been a single Section 2 proceeding brought by the Justice Department, what specifically could Mr. Barr, what would you want Mr. Barr to do to vigorously enforce the Voting Rights Act as he testified yesterday?
I think, number one,
that he should review the decision by the Justice Department to switch sides in these two cases. One has been resolved. Number two, he should ask the voting section of the Civil Rights Division to present to him all instances where the Justice Department has been asked to initiate Section 2 claims. Number three, I believe that he should investigate, evaluate, and review those states that have passed voter suppression laws to determine whether, in fact, they are discriminatory, and, in fact, if they're discriminatory, to initiate a Section 2 claim. The issue is for the Attorney General, and there are many competent lawyers in the Civil Rights Division at Justice, to do their job without political interference, to make recommendations to him on what steps should be taken. A lot of stuff has been put into the deep freeze in the Sessions administration because he was just not interested at all in enforcing the Voting Rights Act because he disagreed with the Voting Rights Act and had had a long career of disagreeing with the Voting Rights Act. Well, the Attorney General does not have an option to pick or choose which laws they want to enforce. They must enforce all laws that are vigorously, because it's your job as the legislative branch to pass those laws. So I think that there are a number of things that the Attorney General can do, and most importantly, to publicly state that he will not follow the policy of Attorney General Sessions when it comes to the entire realm of civil rights. It's important for him to be on the record, as forceful as possible, but also to commit to take the necessary steps to ensure that Section 2 is vigorously enforced, and also to look at those instances where the Justice Department has either switched sides or refused to take a position. The case I mentioned earlier in my testimony, the Chisholm case, which was a judicial reapportionment case in which I was a plaintiff. Case was brought in 1985. It was decided by the Supreme Court in 1991, was a case where the Justice Department sided with us during the Reagan administration. And so the consistency of the Justice Department in siding, taking an affirmative stand in voting rights cases in support of those who've been aggrieved is something that until the Sessions administration was a bipartisan matter. And I think that this nominee should be asked whether he is going to restore that emphasis and that integrity to the enforcement of the Voting Rights Act.
Madam Chair, I'd like to ask Mr. Johnson to respond.
Yeah, I agree with my colleague, but I also think he should intervene in current litigation. There are several ongoing voting rights cases that's taking place across the country. Secondly, he should work to fix the issue around Section 5. The House Special Committee on Voting Rights Act will be doing hearings across the country, from my understanding. And if he becomes the Attorney General, he should seek to also support a fix in terms of Section 5. And then thirdly, review formerly covered jurisdictions to see if, in fact, they've made changes in their policies, practices, or procedures, and if those changes were, in fact, vote suppression methods, so we can document the record to show that without a proactive Justice Department and law, jurisdictions will revert back to past practices of discriminatory actions.
Thank you.